garnishee cases at the High Court, and my 8 years, 10 years plus, 10 years plus now in the Court of Appeal. I particularly remember one of the last I did in this division. The judge came down very hard on counsel and telling them that they seemed not to know what they were doing. It was a garnishee matter. And I think he went too far. But at the end of the day, I felt he too was wrong. The lawyers were right. So that is how these things are. That's why I say sometimes these things, they appear, you have to put yourself in these. That's why I was giving the example of the witches in Macbeth's case. They tell you one thing, and then there is an hidden meaning somewhere. And until you get what they are saying, you will think that you know a lot, yes, yet you don't. So with that, I don't know. The floor, I want to call on my brother. Some of our friends are not here, some of the panelists are not here. Mr. Agom, Professor Agom. Okay, they are following. So I think I will hand over to Professor Agom. You have to coordinate them because I'm backing them, so I won't know how they are following us. So I give the mic. I will also have a lot to say. I'll also have a lot to say myself, having prepared as a panelist.
Tests are available online.
Okay,
Yes,
Kelechi, I know he's my friend.
Yes.
Yes. So how do we start? Who starts?
I think we invite Kelechi SN to start.
Okay. Mr. Kelechi OBSN, who happens to be my friend. I don't know whether you are online. Larry Silk, you are there? Are you there?
Yes,
Can you speak to us, please? Can you talk to us? Thank you, Mr. Obi, SAN. Mr. Obi, thank you so much for your contribution. Please, may we clap for him, albeit even absentia. At the appropriate time, I hope everybody got him. We shall address the issues he has raised. I think we better dispose of both of them, himself and Mr. Hui. I understand Mr. Hui is also ready. Mr. Hui, are you there with us, please?
I'm very much here.
Hui, Wahu. It's a little bit difficult to call, but I did use service in Benin, so I'm familiar with that name. There was a lawyer by that name there. So please, can we hear your own contribution on the issue?
Thank you very much for your part. My words, and I extend my gratitude to Mr. Kelechi.
Mr. Uhunwahu, thank you so much for your contribution. So, fortunately, Abi, somehow you spoke on issues that have been agitating my mind too, even before we get to the next speaker. This issue of cost. First, fishing garnishee proceedings. If you ask me, I hate it. And it is very common, though I understand from the lawyer's viewpoint. You find this situation where counsel will file a garnishee, commence a garnishee proceeding, and most of the time they will serve it on all the banks in the state will be cited. All of them will be cited. In other words, no background check would have been done. They just say, okay, let us see, one will catch them. If this one does not catch them, certainly they are banking here. So the banks are now made to retain counsel. As far as counsel is concerned, he's doing his job. So every counsel to file the counter affidavit or whatever they want to file will charge. They go to court. Everybody will go to court. And then probably for all those banks, it may just be one, and probably even none sometimes. And then you make them incur cost. And at the end of the day, the court in discharging them will just a slap on the wrist. Go home and sin no more. They may not even have sinned at all. It is not fair at all. I've never liked it. Huh? It's not supposed to be done that way. And because of our own attitude to cost, awarding costs in this country, somebody would drag somebody to court for 10 years, and then at the end of the day, probably 50,000, 100,000. It doesn't happen elsewhere. The rules of our courts allow us, I think, how are they even couched? All expenses, reasonable expenses, incurred by the other party. You pay for them. And we have laws, we have similar provisions. I can remember in what is it called? Okotie and Rewan in 1960 or 61 or so, an election matter. After Rewan lost, Okotie came back to say you have to pay for everything. I brought lawyer even from England. So you have to pay for even that lawyer's fees. And the court, Supreme Court said yes. Agreed with him at least to a large extent, not 100%. But he said, look, he's entitled to the fees of his counsel and even one or two juniors. But here, because of the cases, probably most of them by Uwaifu, somebody I respect a lot. I respect him immensely, I must say. That says that it is alien to our this thing is blah, 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 and all that. So you go to court and then you drag somebody at the end of the day, just give you 10,000, 20,000, now 150. It doesn't happen that way in England. When Berezovsky, one oligarch, sued Roman Abramovich, the former owner of Chelsea Football Club, and he lost. All of them went back to court. And then they had to now talk about costs. And they awarded the kind of costs they awarded against Berezovsky was such that Berezovsky has to go and commit suicide out of fear of how he would pay. That is how it is done elsewhere. You have to pay for, even if the other counsel on the other side, the other party on the other side, even if he engages just an ordinary person to investigate, that fees too you have to pay. Those the fees of that person you have to pay. That is how it is done. So I completely understand your position, Mr. Uhunwahu. The way we do is not proper. What I don't seem to agree with you is where you said that the bank should be given for 3-4 yearly notices. No, that would be indulging them too much. That would be indulging them too much. We know how sometimes you operate. You see this and then you think that it doesn't really matter. You look at your banking issues. This is just a distraction. Well, you pay for it. You pay for it if you don't. That's the part I don't agree with you. But for every other thing, I completely agree with you. So please, can we give Mr. Uhunwahu one more? Can we clap for him one more time? Thank you so much, Mr. Uhunwahu, from your distance. Thank you so, so much. I think now we can come back to our professor. Please, your name, sir. Okay, Professor Akume by my side. Please let us also hear your own contribution, your own view of it. Thank you so much, Prof. Please, it's over to you.
Okay. Thank you, sir. All protocols duly observed. First, when you look at the law, I think, or let me start this way. There's always a presumption that because somebody is a judge, he knows all the law. There are situations that even the judges don't even know the law because they have not studied and interrogated the law enough to be able to give an informed judicial opinion on the matter. And that is why we have been having a drag on this. Prior to 2017, the position of the courts had always been that the judgment debtor is never to be had in garnishing proceedings. But in 2017, the Court of Appeal departed from that. There is this case of Unilag versus Odeyemi, 2017. There is another case of Nigeria Appeal, Nigeria Ajib Oil Company versus Peter Ogini, that was 2010, where the Court of Appeal departed from that and held that garnishing proceedings, once it has proceeded to the point where you have gotten a nice eye and you are moving to absolute, it is now a tripartite proceeding, which involves the judgment debtor, the judgment creditor, and the garnishee. Now, prior to this time, why didn't we know, why didn't the court hold that judgment debtor was a necessary party? Not until this 2010 in Nigeria Ajib Oil Company versus Peter Ogini, and then also followed in 2017 in Unilag's case. Now that was a departure. It means that was the time the courts began to see the light. But the position of the law had always been there. If you look at section 83 subsection 1 of the Sheriff and Civil Processes Act, it says that the court may, upon ex parte application of any person who is entitled to the benefit of a judgment for the recovery of payment of money, either before or after any oral examination of the debtor liable under the judgment. Section 83, subsection 1. Now, what brings about either before or after any oral examination is giving us a hint. In subsection 2 of section 83 of the Sheriffs and Civil Process, it says, at least 14 days before the day of hearing, a copy of the order NISA shall be served on the garnishee and on the judgment debtor. Why would the statute be saying that after you obtain a garnishee order NISA, you must serve the judgment debtor and the garnishee? Do you serve the judgment debtor for the fun of it? Is it not for the purpose of him being heard? That was the basis upon which IKJCA in Unilag's case held that this is a tripartite proceeding. The judgment debtor, in that case, Unilag, was entitled to be heard and was entitled to bring an appeal, even though they are the judgment debtor, they are not the garnishee, because they were objecting to the garnishment of their account. So that is what led me to the hypothesis that we should not always assume. Lawyers should be able to make a very strong argument so that there can be development in the law. Now, the next issue I want to talk about stems from something that happened at the National Industrial Court, Kaduna. I had a matter there, and before my matter came up, somebody brought a fishing expedition of a garnishee, like the other party speakers were saying. All the 25 banks in Nigeria were parties. And my Lord was asking, you have brought 25 banks before me to get an ex parte order. Which of these banks does the judgment debtor have account? He said, well, they don't know, but if the ex parte is given, they will take it and serve all of them. She now said, if you serve all of them and they appear before me and there is no account with them, are you ready to give undertaking as to cost to compensate them for bringing them before me when you have no case against them? Because I've read the Sheriffs and Civil Processes Law. I have not seen anywhere where the law says you must bring somebody, a garnishee, who does not hold funds that are to the credit of a judgment debtor. You bring a garnishee to court only because the garnishee is somebody with whom the judgment debtor has funds. A garnishee is somebody who holds funds on behalf of the judgment debtor. Now the bank that you brought, does it qualify as a garnishee? Is he holding any funds that belong to the judgment debtor that we can attach? Why do you bring him before the court? Does that not amount to a frivolous litigation? Bringing somebody to court that you don't have, that is why we call it a fishing expedition. So, for me, I believe that her lordship did the right thing. And she said, go and do a due diligence. Isolate the banks that you believe have funds and come back, file your garnishee proceedings against them, and I will list them. But you must place sufficient facts before me in your affidavit that shows that those banks have funds belonging to the third party. But you cannot come and make me to give an order against somebody that you didn't place facts before me to show that there is a judgment debtor funds with the person. And the lawyer now withdrew his application and said he will go home and do due diligence. I was happy with that. And I believe that her lordship did, in my opinion, what is right. Now, the next issue. A bank that does not have judgment debtor funds with them receives an order NISA. The law is that they should appear to show cause why funds that are with them should not be attached. The question is, which funds? Appear to show cause that which funds should not be attached. Funds that facts have not been laid before the court to show that the bank is holding funds. You are asking the bank to come and show cause why the funds should not be attached when there is no funds at all. The judgment creditor's lawyer himself has not done his due diligence to place enough facts before the court to move the court to exercise its judicial powers to give the order. The courts are not Father Christmas to be giving orders that cannot be carried out. So in my view, if a judgment creditor brings garnishee proceedings before the judge and cannot lay enough facts before the court to show that Bank A, B, and C are holding funds that belong to the judgment debtor that should be attached, if the bank does not appear and you are moving me as a judge that I should give an order, I'll say, okay, place enough facts to show. If you can show me that this bank has, the judgment debtor has funds in this bank, and the bank has deliberately refused to come to show cause, when I see enough evidence, I will give an order absolute. But I will not give an order absolute if you cannot place enough facts before me to show that this bank that did not appear has funds. Alternatively, you give an undertaking as to cost. That will make lawyers to stop fishing expeditions, but to go back and do due diligence in order to find, so that you bring the proper banks before the court, and if they refuse to appear, then there is enough evidence before the court for the court to now issue order absolute. If we look at Order 8, Rule 6 and 8 of the Judgment Enforcement Rules. The Judgment Enforcement Rules were made pursuant to Section 94 of the Sheriffs and Civil Processes Act. The Judgment Enforcement Rules are the civil procedure rules by which you proceed with garnishing proceedings. And in the citation, they are cited as subsidiary legislation to the Sheriffs and Civil Processes Act. And Order 8, Rule 6 and Rule 8, there is something very consistent in the two rules, which says that the court may, after hearing the judgment creditor, the garnishee, and the judgment debtor if he appears, make such order as to the payment of the judgment to the judgment creditor of any sum found to be due from the garnishee to the judgment debtor. So the rule says the order the court is to make is after the court has had the judgment debtor, the garnishee, and the judgment creditor, then the court will proceed to make an order absolute against any sum found to be due from the garnishee. Now, if there are no funds due from the garnishee, what are you attaching? So I conclude by saying, the law has moved. When you want to go for your fishing expedition, please, the courts should be very firm to ask lawyers, place facts before me that will make me give an order nicer. Because this is an ex parte application where the other side is not being heard. You are unfair to the banks by coming here to ask me to give an order nicer attaching funds when you cannot prove there are funds there. Why should we shift the burden to the banks when the judgment creditor's lawyer is the one who's supposed to do his due diligence? So if he has done his due diligence and you give another nicer, then you serve the other nicer on the judgment debtor and on the garnishee within 14 days and fix a date for hearing. And at the hearing, let them come and show cause why the funds in those accounts should not be attached. But to say the judgment debtor is not a party, I think that Section 83, subsection 1 and 2 of the Sheriffs and Civil Processes Law and Order 8, Rule 6 and 8 of the Judgment Enforcement Rule have made the judgment debtor a necessary party. So the court should please help the banks. I don't work in the bank. I'm an academic and a practitioner. I don't work in the bank. But what I'm making this is advocacy that our judges should please make judgment creditor lawyers to go and do due diligence before coming to court. It is because the court is always indulging them. So they just you will see one case, you will see 25 banks, 25. Well, a judgment debt of 1 million, you will bring 25 banks. The man, if he has money, we will share 1 million between 25 banks. Why should we go and be giving order and then they will hire a lawyer and appear to show cause? No, there should be security as to cost. So if that happens, no lawyer will bring garnishing proceedings and then expect to go free like that. Thank you very much, Mr. Chairman.
I like the way the prof spoke. He spoke with passion. I'm sure if the banks have a way, they may want to parcel something for him for making such a good case for them. Please, may we give him another round of applause. Yes, I just want to, before I go to my brother, the president of NICN, I just want to say for now that I agree with the prof completely on the issue of service or the parts of a judgment debtor in garnishee proceedings. You see, I've always, the authorities, as it used to stand, as they used to be, I've always doubted them. You see, Section 83, Sub 2 of the Sheriff and Civil Processes Act says that the garnishee and the judgment debtor should be served at least 14 days before the hearing of the other absolute. I think I have it here.
Yes, sir.
Now, if that be the case, I had one case before I even get to it. In Bogoro versus something, it is reported, which I did in Jos. The trial judge was deceived by this kind of argument, obviously with UB and Ekanem and cases along that line, that a judgment debtor has no part to play. So, if this being there was for no use. So in that case, in that Bogoro's case, which was, I think, the local government was represented by, is it the local government? No. I think the judgment that also was represented by now Chief Kutu SAN. I think he was able to convince the trial judge along these lines to say, what is the judgment debtor doing here? Such that even after the judge had adjourned the matter, he brought it back again and then said, look, there is no point hearing the judgment debtor, so I'm not going to adjourn it again. And then gave judgment against the entire judgment, made it absolute. Because the judgment debtor came on appeal to us, and to me it was very easy. If the lawmaker says, without any distinction, that the judgment debtor and Biganishi should be given the same number of days, and says it shall be at least 14 days. So do you then mean that his own 14 days is to go and wear his Jumat dress or Christmas dress to come and watch proceedings? That he has no part to play? It doesn't make any sense. When the lawmaker says it has to be given 14 days, at least 14 days, he doesn't have to say that this is what you are coming to do. It is implied that he has a part to play in the Ganishi proceedings. Fortunately, this court, our court, I don't think it is an issue. Like Mr. OBSN, with all due respect to you, made, I don't think it's still an issue before us. That issue has been settled. In Dumuje versus Nigeria Breweries, I think somebody mentioned it. Was it the other person that mentioned it? The Court of Appeal, Benin, our brothers, presided over by Ogun Miju now in Supreme Court, had to invite counsel, private counsel, quite a number of them. And then they reviewed all those authorities, and they arrived at the conclusion that a judgment debtor is a proper party to Ganishi proceedings. And that is the only way it should be. Supposing a judgment debtor, Ganishi proceeding does not, yes, it is sui generis, it is a special way of execution, but it does not in any way take it away from the fact that it is a way of execution itself. So you can imagine if the judgment debtor has appealed, has filed an appeal, and is contesting the judgment. Remember, especially some of the judgments, if it's at the high court level, you still have two courts upstairs. One person has said, yes, this person has won. The law allows him to go and test it, not just once, but twice. And then the man is testing, he has filed an appeal, and then you say, oh, even though he has been served the Ganishi proceedings, the other to show cause that he has no part to play, that he cannot even come and tell the court that, look, I'm challenging this judgment, so I should be heard. So stay proceedings. It doesn't make sense. That is how it should be. So, Mr. Leonard Prof, I agree with you completely. Completely. Even on just mere this thing. It does not need much reasoning to realize. Somebody is saying, oh, the court that gave judgment does not have jurisdiction for one reason or the other. I have been, when I was in in Jos, some of these people, these get-rich-quick scheme people, that they gave some money to somebody, to one of the get-rich-quick men. Everybody went and invested huge sums of money, as they normally do. And then at the end of the day, it turned out that the thing was fake, was all, what is that thing they call it?
419.
No, I think there's a name they call it. Ponzi scheme. It turned out that it was a Ponzi scheme. So, the bank appealed. And they went there to Ganishi, so the bank appealed. That, look, they went to court and got judgment, actually, from the High Court, State High Court, and got judgment. And then the bank appealed to say, look, this one, you don't have jurisdiction. The State High Court does not have jurisdiction. Because the State High Court, by virtue of Section 251, I think 1D or so, only has jurisdiction when it is an issue between a bank and its customer. These people are not our customers. So they couldn't have properly taken us to the High Court. The proper place is Federal High Court. Now, in that kind of case, you mean that the judgment debtor should not be heard? I mean, it doesn't make sense. Just because they garnishi, that you should keep quiet, and then the other people should get their money from the bank, from the garnishi. It doesn't make any sense. So I just wanted to add that, Prof, to that extent, you are very, very much in order. Thank you so much for your contribution. I think the next one is to my brother by my right. He has encyclopedic knowledge of these things, even before he became president. I knew him, though he doesn't know me. I'm sure he just seeing me probably for the first time. So, my Lord Kanyip, over to you, sir.
Thank you, my Lord. I actually know my Lord, so I've been given an opportunity for a second bite at the cherry. Some things I wanted to say yesterday, I couldn't say. I came in to listen to what the panelists would say on garnishi. I ended up being a panelist. I want to draw attention to one or two issues, particularly dealing with literal interpretation of sections 83 and 84 of the Civil Sheriffs and Civil Process Act. But in addition to that, I want us to have in mind section 287 of the Constitution and the Interpretation Act, because they go to enabling us understand fully the naughty areas when it comes to garnishing. And the principal question which you would find is whether CBN is a public officer. Secondly, and I agree with Professor Akume, the practice of listing all banks in Nigeria does not even have a basis with the literal interpretation of Section 83 of the Sheriffs and Civil Process Act. And there are one or two Court of Appeal decisions on that. I will draw attention to that. Now, as a preliminary point, under Section 83, the supporting affidavit for any application for a garnishee order, what Section 83 says is that that affidavit is to be deposed to either by the applicant or his counsel. Here I want to draw attention to a point I made in my paper meant for yesterday, but which I didn't have the opportunity to stress. This is an example where if the law wants a counsel to swear to an affidavit in a process, it permits him to do. And I'm saying this point relative to the practice I see every day, where counsel swear to activating affidavits that activate courses of action. And I have had cause on some occasions in court to ask counsel whether in filing an originating summons and swearing to the affidavit or getting a litigation clerk or a secretary in the office to swear to that affidavit, there is a competent suit before me. And counsel had said, look, the litigant wasn't there, we needed to do this. And I was like, even aside from the fact of competence of the suit, Do you think you're doing the profession any good? Swearing to an affidavit simply because the litigant feels too big to come to court and swear to affidavit. You sit in your office and a litigant calls you and tells you 1,001 stories. In any event, when you tell a litigant, a litigation clerk, to swear to affidavit, and the man tells you, what I say is based on my knowledge or what I was being told, and the sources are indicated, I ask a simple question. Do you think it's logical that a client will come to your office and be debriefed by a litigation clerk? So on face value, that affidavit itself is wrong in terms of the veracity or the truth or otherwise of what is stated. But I'm more concerned with the dignity of the profession. If somebody sits in his house and gives you instructions on phone and refuses to come to court to swear to affidavit, and you as counsel, you are doing it, aside from the fact that it impugns on the competence of the suit, you are yourself demeaning the legal profession, because what you are saying is that this man is too big to come to your office and properly brief you, or he's too big to go to court. So I have in one or two instances held that if you do that, I strike out the case on grounds of incompetence, because as far as I'm concerned, you as counsel, you are not competent to swear to an affidavit to activate an originating process. This is just an aside. Now, under this same section 83, I want us to mark these words. They are somewhere in the middle. I don't want to read all of it. Professor Akume started reading part of it and stopped somewhere. I think he stopped at the point of either before or any oral examination of the debtor liable under such judgment. And upon affidavit by the applicant and his legal practitioner that judgment has been recovered and that it is still unsatisfied, and to what extent, and this is where I want us to note, and that any other person is indebted to such debtor. Any other person is indebted to such debtor. It tells you there has to be a specific debtor who is indebted to another person. And you don't just bring anybody whom you don't know is in fact indebted. Then he said, and is within the state. Order that debts owing from such third party, hereinafter called the garnishee, to such debtor, debts owing by that person to such debtor, tells you that on a literal interpretation, there has to be an actual debt being owed. When you carry all banks without indicating who is actually indebted, you have not kept to the literal words of this particular section 83. And quite rightly, in 2021, Court of Appeal ruled that that practice of listing all banks is not in conformity with this particular provision. And I agree with it. Now, Section 287 of the Constitution, if you look at it, whether it is in relation to Supreme Court, Court of Appeal, or the High Courts and the equivalents, talk about judgments shall be enforced in any part of the Federation by all authorities and persons. By all authorities and persons. Is Central Bank of Nigeria an authority or person for this purpose? The answer is yes. Now, when the Sheriffs and Civil Process Act under Section 84 talk about getting the consent of the Attorney General, I'm coming again to the literal interpretation very soon. But when it talks about the literal interpretation, the question of Attorney General giving consent, is it in reality in conformity with Section 287? When you place a condition for the enforcement of a particular judgment, when the Constitution says a judgment shall be enforced by all persons and authorities, are you keeping in terms with it? I am not unmindful of Court of Appeal decisions like CBN and Shipping Company, CBN and James HMB, where the Court of Appeal said that the constitutionality of Section 84 of the Sheriff and Civil Process Act has already been settled. It being that Section 84 of the Sheriffs and Civil Process Act is not unconstitutional relative to Section 287. My argument, in fact, I had a private discussion with retired Justice Ejembi Ekwo. He even drew my attention to this point, whether Section 87 can withstand, Section 84 of the Sheriff and Civil Process Act can withstand Section 287 of the Constitution. As it is, I'm not aware that that issue has gone to the Supreme Court. The authorities available on ground right now are Court of Appeal decisions, and the Court of Appeal decisions say that Section 84 is not unconstitutional. But my viewpoint is to disagree with that stance. I sincerely believe that even on grounds of constitutionality, the requirement that you must get an Attorney General's consent before you can enforce a judgment is contrary to Section 287. But of course, we await when that issue will get to the Supreme Court. Now, let's go to the literal interpretation of Section 84. And I want to read it out, and as I read it out, I want us to note some things. In subsection 1, it says, where money liable to be attached by garnishing proceedings is in the custody or under the control of a public officer in his official capacity. Please mark the words his, in his official capacity. The Interpretation Act, aside from defining what a public officer is, I will come to that, says each time the he or his is used in a statute, it includes the she. But nowhere in the Interpretation Act is it stated that the he in including the she includes the it. Nowhere. So, is CBN as an artificial entity capable of being referred to as his capacity? I don't think that's proper or correct. I know of normal semantics where we refer to countries as she, we refer to companies as she in the line of gender mainstreaming language and things like that. But for purposes of the Interpretation Act, all we are told is that the he includes the she. So if Section 84 talks about this public officer holding money in his official capacity, it presupposes that it is dealing with human beings, not artificial persons. So if we understand it from that angle, then automatically it becomes true that CBN cannot be public officer for purposes of the Sheriff and Civil Process Act. In any event, the case that actually first ruled that CBN is a public officer relied on Ibrahim versus Kaduna JSC. But yesterday I talked about, in law, context is everything. You must read these things in their proper context. When Ibrahim and Kaduna JSC was decided, it was decided on the sole purpose whether an artificial person is a person for purposes of the Public Officers Protection Act. It was not decided on the basis of a definition of a public officer. It was whether an artificial person qualified as person, because other than the title Public Officers Protection Act, nowhere in that act is the word public officer even used. The word used is person. And it is because of this lack of, how do I put it? Lack of this detail that even a secondary question, which is whether non-public officers can benefit from the Public Officers Protection Act. There is a recent decision I saw of the Court of Appeal, Court of Appeal, I think 2021 or so. It was, I think, Justice Abiri, who is now in the Supreme Court, who decided and said, because of the title Public Officers Protection Act, non-public officers cannot benefit from it. Meanwhile, in 2015, there was a decision, in fact, two decisions of the Supreme Court, where they held specifically that the title is deceptive in making you think only public officers can enjoy that protection. But that if you look at the language in terms of the wordings of the respective sections of that act, nowhere is the word public officer used. It is person. And because it is person that is used, the Supreme Court held that non-public officers can benefit from it. So, coming back to Section 84, the question is, in fact, if you go to the subsection 2D, it talks about, in 3A and B, it talks about, in this section, appropriate officer means A, in relation to money which is in the custody of a public officer who holds a public office in the public service of the Federation. Now, Section 18.1 of the Interpretation Act defines public officer as, and I quote, a member of the public service, mark my words, a member of the public service of the Federation within the meaning of the Constitution of the Federal Republic of Nigeria 1999, or of the public service of a state. Now, it talks about a member. Can CBN be a member of the public service? Can CBN be a member of the public service? Once again, what is contemplated are the human beings who occupy the respective offices. So, once we understand this literal interpretation, it cannot, by any stretch of imagination, be concluded that CBN can be a public officer for purposes of the Sheriff and Civil Process Act. I did a rundown of some Court of Appeal decisions after Itasela. Majority of the decisions, and I did it deliberately, I'll just give you a sample. Just a minute, Chairman, sir. If you look at EcoBank Nigeria PLC versus Admiralty, decided in 2021, that decision, Court of Appeal held that CBN is not a public officer. CBN versus Triple C, decided on 8 April 2022, decided that CBN is not a public officer. CBN versus NX2 Merchant and Nigeria Limited, decided on 29th April 2022, decided by Samani, then JCA, now JSC. He decided that CBN is not a public officer. CBN versus Macti Trading, decided on 29th April, same conclusion, CBN is not a public officer. CBN versus Gruka Brent and Co. Nigeria Limited, decided on 29th April 2022, decided that. Then we also have CBN versus Elder Abdul Ezenya and then Access Bank, decided in June, on 2nd June 2022. Now, I want to draw attention to the converse decision by Justice Idris, then JCA, who is also now at the Supreme Court, he held that CBN is a public officer, but his decision was on 10 March 2022. Of course, on the basis of follow the most recent rule. You will know that the Samani decision came later in time. But I want us to understand the rationale he used in coming to that conclusion. And this is what he said. It is therefore my decision that after considering the arguments of learned appellants counsel in the appellant's brief of argument alongside the reply brief of argument and the authorities contained therein, that the trial court had no jurisdiction to entertain the garnishing proceedings against the appellant vis-a-vis the provisions of Section 84 of the Sheriff and Civil Process Act and Section 318 of the Constitution of the Federal Republic of Nigeria, as amended. The appellant being a public officer, and the appellant was CBN. The appellant being a public officer, the first respondent needed to obtain the prior consent of the Attorney General before instituting the garnishing proceedings against the appellant, as the said Section 84 of the Sheriff and Civil Process Act is mandatory. It would be absurd, this is the rationale, it would be absurd to interpret a public officer in Section 84 of the Sheriff and Civil Process Act in the restrictive sense as interpreted on the basis of Section 318 of the 1999 Constitution alone, because if so done, the safety measures put in there for government funds would have been defeated. Government funds kept in Central Bank of Nigeria are not kept with a particular individual who is a public officer. This is why the interpretation given to public officer in the case of Ibrahim vs. JSC by the Supreme Court should apply to all cases. It should therefore enjoy or be given a general application instead of limiting the definition to public office holders. Now, the question is this. When you go after CBN as garnishing, the funds you are attaching, are they CBN funds? I have had cause to ask the lawyer to CBN who came before me, what's your own? Even the judgment debtor who was in court did not object to the funds being attached. It was CBN as CBN who was opposing. And I asked CBN's lawyer, are the funds your own? What is it? What interest do you have in it? When my lord said he had government funds in CBN, I think my lord did not avert his mind to the fact that not all funds in CBN are actually government money. Not all. So when I proceed against an ordinance of the colonial administration, certainly did not contemplate, nor could it have contemplated the Treasury single account policy and the attendant consolidation of all inflows, payments, and receipts from all agencies of government into a single account or a set of linked accounts at the Central Bank of Nigeria, which makes the CBN a necessary party in the deluge of garnishing proceedings filed in the wake of the TSA policy. But as demonstrated, the definition of public officer in Section 18 of the Interpretation Act clearly excludes governmental bodies and institutions, including CBN. And the decision of the Supreme Court in CBN versus Interstellar is that the CBN, which acts as a banker to the federal government with respect to government funds, in its custody, pursuant to Sections 2 and 36 of the CBN Act, does not stand as a public officer in this situation, and no necessity arises to seek the consent of the Attorney General as a precondition for initiating garnishing proceedings against CBN. It would seem, therefore, that the answer to the question posed in the caption of this chapter is necessarily in the negative. Thank you.
Gentlemen, you can now agree with me that when I said my Lord has encyclopedic knowledge, no paper prepared, nothing, and yet he has spoken as if he had a paper on it. Thank you so much. Please say, I think he deserves, my Lord deserves another round of applause. My Lord, I agree with everything you've said here. Fortunately, it's as if you spoke, as if you knew what I was coming to say myself. Though I will approach the issue not from the angle of Section 287, I believe that even the whole of Section 84, probably not the whole, at least the part that says that you need the consent of the Attorney General, I am of the view that it is even unconstitutional. Unconstitutional from my own view, not from 287. I've not really looked at it, so I cannot comment on it. From another angle, fortunately, I had to make a paper. But before I say that, I want to just make the point that garnishees need not necessarily just be banks, as we do here. Is anybody that is indebted to the judgment debtor. So it could even be just an ordinary person, or anybody in fact, that is owed, that is indebted. And I want to also make the point that the debt must be debt that is already owing, not a debt that will be in the future. That is why you can garnish somebody's salary, but you cannot garnish what he has not earned. It is only a salary that is already due to him, which he himself can sue, that you can garnish. But that having been said, I titled my own contribution as a panelist that I was supposed to be. I titled it whether Section 84 sub 1 taking the consent of the Attorney General a requirement for attachment of monies of government and its agencies is constitutional, and 2, which is what my learned brother addressed extensively here, which is whether the Central Bank of Nigeria is a public officer within the meaning of Section 84(1) of the Sheriffs and Civil Process Act. This is the way I tackled it. I said I first reproduced, thank you, my brother, Prof. Yes, I first reproduced Section 84 sub 1, which goes this way. Of course, we all know where money liable to be attached by garnishee proceedings is a custody under the control of a public officer in his official capacity in custodial legis. The other 9 sides shall not be made under the provision of the last preceding section unless consent to such attachment is first obtained from the appropriate officer. In the case of money in the custodial control of a public officer of the court, or in the case of money in custodial legis, as the case may be. Then he goes on to say, in such cases, the order must be served in such public officer or the registrar, as the case may be. In this section, appropriate officer means relation to money which is the custody of a public officer who holds a public office in the public service of the Federation, the Attorney General of the Federation. Then there's a B part which relates to state. And then this is the way I tackled it. I said my personal view is that this provision, to the extent that it purports to subject or ties the execution of a judgment pronounced by courts to the consent of the Attorney General, conflict with sections 1 sub 1 and sub 3, as well as section 6 sub 1 and 6b sub b of the 1999 Constitution of the Federal Republic of Nigeria, vesting judicial powers exclusively on the courts. Section sub 1 says the judicial powers of the Federation shall be vested in the courts to which this section relates, being courts established for the Federation. While 2 says the judicial powers of the state shall be vested in the courts to which the section relates, being courts the same provision. Then subsection 6(1), 6b, 6 sub 6 paragraph b says the said judicial powers shall extend to all matters between persons or between government or authority. and to any person in Nigeria, and to all actions and proceedings relating thereto, certainly, garnishee proceeding is one of them, for the determination of any question as to the civil rights and obligations of the person of that person, end quote. And then I went on to say that garnishee proceeding commenced by a person to execute money judgment against government or its agencies is surely within the meaning of actions and proceedings relating thereto, quote and unquote, therein. It is therefore against the spirit and words of the Constitution to make such proceeding subject to the consent of the executive branch of the government through its Attorney General sitting as another review court, so to speak. It even becomes more obnoxious when it is realized that the same Attorney General is most times the defendant or co-defendant in even the case itself. Now, Section 1, Sub 1, and 3 of the 1999 Constitution, stating that the Constitution is supreme, states that the Constitution is supreme and its provisions shall have binding force on all authorities and persons throughout the Federal Republic of Nigeria, and that if any law is inconsistent with the provisions of the Constitution shall prevail, and that other law shall, to the extent of the inconsistency, be void. I went on to say that it makes no difference, in my opinion, that Section D of subsection 6D states that the competence of any authority or person to make any existing law, which is defined as a law made on or before 15 January 1966, which of course includes the SPCA, which was first made in 1945, shall not be questioned. What is in issue is not the power of the authorities to enact the SPCA and its provisions, but the constitutionality of the specific provision of a Section 84. In any case, Section 315 of 1999 Constitution of the Federal Republic of Nigeria rather states categorically that an existing law, which the Sheriff and Civil Process Act is, shall only have effect with such modifications as may be necessary to bring it into conformity with the provisions of the 1999 Constitution. Now, I said in the course of preparing this paper, I had the good fortune of stumbling on the views of the revered Silk, Chief Afe Babalola, OFRSAN, on the same topic in his book Enforcement of Judgments, first edition, 2003. The learned Silk there first remarked in his preface to his book, quite a big book. Thus, he said, as on the preface, that worthy of note is the special emphasis I have placed on garnishee proceedings because of the myriad of controversies surrounding the right of a successful litigant to attach monies belonging to the government or government agencies. He then continued, he then tackled the issue in the following manner headlong. And this is what Chief Afe said. He said, under the 1999 Constitution, quote, I'm quoting him, all classes and manner of people, including governments, can sue or be sued, subject only to the rule of law relating to such issues like local standard. Access to court and enforcement of decisions, therefore, should not be inhibited by anybody, including the government and its agencies. The position under the Constitution is that in matters of enforcement of judgments, there should be no distinction between remedies available against the government and those available against any other person. This view is further reinforced by decision in Federal Civil Service Commission versus Laoye, cited 1989, where it was said that justice is a four-way thing, a justice to everybody, to the plaintiff, to defendant, and even to society. Where he said, when the court is described as last hope of the common man, that is what the Supreme Court said, the common man, that implies that it is the duty of the judiciary, a duty which is owed to the cause of justice, to ensure that any encroachment on the rights of the individual, any coercive action is justified by law. In the unequal combat between those who possess power and those on whom such power bears, the court's primary duty is protection from the abuse of power, end quote. He said, therefore, once issues are turned, this is what he said, therefore, he continued on his own now to say, therefore, once issues are turned over to court by disputing parties, be it private individual, quasi-private individual, or private individual, quasi-government, then the outcome of the trial should be binding on parties thereto. In the absence of any disabling rule of law with regard to the jurisdiction or appeal, and in the absence of stay of execution or injunction against all persons, including government granted by courts, courts of law have a duty to enforce their judgments. To accept any contrary reasoning to the above is to go against the times repeated injunction that the courts will not make a habit of depriving a successful litigant of the fruits of his litigation, end quote. The learned Silk next took up the specific question of garnishee proceedings against the Central Bank of Nigeria, which my learned brother has addressed comprehensively here, as regards monies of government and its agencies deposited with it. Then he argued again like this, his lordship argued again this way. He said, an interesting question to ask here is whether money held by the Central Bank of Nigeria on behalf of the government or any of its agencies is liable to be attached by garnishee proceedings without the consent of the Attorney General. He said, before considering the constitutionally or otherwise of Section 84 quoted above, it will be pertinent to examine if such money can be shielded from garnishee proceedings by virtue of the provisions of Section 84. He said, by the combined effect of Section 1 sub 2 and Sections 3 to 41 of the CBN Decree number 24 of 91, the Central Bank of Nigeria carries out the functions of a bank and is therefore in law and in fact a bank simpliciter. This position is strengthened by the definition of quote and unquote banking business in Section 61 of BOFID number 25, which provides as follows, in smaller quotes, says banking business means the business of receiving deposits on current account, savings account, or other similar accounts, paying or collecting checks drawn by or paid in by customers, provision of finance or such other business as the governor may by order published in the Gazette designate as banking business, end quote. Then he continued, he said the Central Bank of Nigeria, the CBN, is a banker, not only to the federal government and its agencies, but to states, local governments, as well as other banks. It has been held that money in a bank is not in the hand of a public officer, as a bank is not a public office. See Adedeji versus Balogu, because there are a lot of authorities, which this author was the applicant's counsel. That is a chief affair. Thus, money in the Central Bank of Nigeria is not per se money in the custody and control of a public officer, but money being held by a bank for its customer. This position is further strengthened by Section 3A of Section 84 of the Sheriff and Civil Process Act, which provides as follows, he quoted it. The Central Bank is not and cannot contend to be a public officer who holds a public office in the service of the Federation, which is the argument my brother also made here, in respect of money it is holding for the government and its agencies. This has clearly obviated the general conclusion that money deposited in the Central Bank of Nigeria is money in the custody or control of a public officer, and as such is subject to the provisions of Section 84. Even if the above provision is wrong, there remains the infallible legal position that Section 84 of the Act is unconstitutional and inconsistent with the 1999 Constitution. End quote. The learned Silk still said something, but I think I've read enough. What he said in addition is almost repetitive of what he has seen. Now, on my own, I said one can hardly add to this argument. I said, fortunately, there even seems to be high judicial authority in support of it in the case of Adedinro and another versus Interland Transport, which was decided in 1991, Nigerian Criminal Reports Part 214155. Incidentally, Chief Affair was also involved in that case. There, Karibi White, JSC of blessed memory, in his leading judgment, with his brothers Ways, Belgore, Wali, and Olatawura, all in agreement, add this to say at pages 25 to 26 of Law Pavilion Election Law Reports. And this is what his lordship said, which is, to me, is very germane to the argument, to the issue, to the discourse here. His lordship, Karibi White, said about this consent of Attorney General in laws, all of which I will say, including that in the Sheriff and Civil Process Act, we inherited from England. His lordship said, add this to say, he said the basic law of the country, this country, is the Constitution of the Federal Republic of Nigeria 1979, which came into force on the 1st October 1979. Section 1, sub 1 makes the Constitution supreme and its provisions have binding force on all persons and authorities throughout the country. It is important to refer to Section 50 of the Constitution, now Section 315 of 1999 Constitution, which provides that all existing laws shall have effect with such modifications as may be necessary to bring them into conformity with the Constitution as amended, suspended, or modified. There is no doubt that the common law of England is a law existing at the coming into force of this Constitution. It is therefore an existing law within the meaning of Section 274, sub 4, sub 3 of the 1999 Constitution, not this present one. And then what he said, this is the one that even concerns me most. His lordship went on to now say that the Constitution has vested the courts with the powers for the determination of any question as to civil rights and obligations between government or authority and any person in Nigeria. See Section 6, sub 6, paragraph B. Accordingly, where the determination of the civil rights and obligations of a person is an issue, any law which imposes conditions is inconsistent with the free and unrestrained exercise of that right is void to the extent of such inconsistency. Thus, the restraint imposed at common law on the right of action in public nuisance is inconsistent with the provisions of Section 66, Paragraph B of the Constitution 1979, and to that extent is void. Then he hit it on the nail directly like this. He said, His Lordship said, I think the high constitutional policy involved in Section 6, sub 6, Paragraph B is the removal of the obstacles erected by common law requirements against individuals bringing actions before the court against the government and its institutions, and the preconditions of the requirement of the consent of the Attorney General. This becomes the more important when the provisions are procedural encroachments designed to protect peculiar social or political situations, end quote. I think that is the point that has to do with what my brother was saying here about what my friend and now senior learned brother Idris said about protecting government monies and all that. So when government sues somebody, you get the money. But when somebody sues government, you have to go back to meet Attorney General, who probably have been defeated in court with all the best of the arguments he has made. He might as well even be telling you, come, don't worry, be making your argument. Be speaking your Dogon Turenchi here. You come and meet me for my attorney, for my consent, and see whether I will give you. That is not supposed to be the way the law is supposed to work. The Constitution doesn't operate that way. Fortunately, this provision is actually a carryover from the Crown Proceedings Act, Section 27 of the Crown Proceedings Act of 1945, yes? 47, which says the crown money is in the crown, you cannot go after them, and the salaries in national whatever are not subject to a garnishee proceeding. That is what we have till today. Then I went on to now tackle this issue of Interstellar, which seems to be the biggest case, garnishee case that have ever been to the Supreme Court. I said in Central Bank, these are my own words now. I said in Central Bank of Nigeria versus Interstellar Communications, which has been the subject of a lot of differing interpretations by our learned brothers, by my learned brothers of the Court of Appeal. The Apex Court, by its leading judgment by Ogumbi EJS, tackled the same argument of Central Bank of Nigeria, being a public officer under Section 84 of the Sheriff and Civil Process Act, and so government monies deposited with it requires consent of the Attorney General for their attachments. Our Lordship dealt with the issue this way at page 346. This is what our Lordship said. The other leg, he said the other leg, she had treated one leg before. The other leg of the argument is where the Appellant's Counsel holds out that CBN is a public officer and relied on the case of Ibrahim versus JSC Supra, that is the Kaduna case in particular. In that case, under consideration, I have ruled that the relationship between the appellant and the third and first respondents is that of banker and customer relationship. In other words, as rightly argued by the first and second respondent counsel, the appellant is not a public officer in the context of Section 84 of the Sheriff and Civil Process Act, when regard is hard to the history of this appeal. Section 84 has been earlier reproduced in the course of this judgment. It is apparent therein on the facts of this case that the CBN acts as a banker to the federal government funds. With respect to government funds in its custody, the appellant does not stand as a public officer in this situation. Therefore, it follows that the need to seek the consent of the Attorney General of the Federation does not arise. The case of Purification Tech Nigeria Limited versus AG is on all fours, end quote. That is what our Lordship said. I went and then I came back again. I said, I am not unmindful of, in saying this, I'm not unmindful of the argument usually made on the other side to the fact that the ratio decidendi of Central Bank of Nigeria versus Interstellar Communications is the first reason also given by His Lordship Ogumbi that the Attorney General in Interstellar's case, having already ordered part payment of the judgment that he issued to the respondent, he was stopped from contending that he had not given consent to the attachments. That is the argument a whole lot of my learned brothers normally make when they want to take positions on the other side. I said, with all due respect, I have always believed and held that this is not a correct representation of the ratio of Central Bank versus Interstellar. In my two leading judgments in CAJ 46/2018, Central Bank of Nigeria versus Zenith Bank of Nigeria PLC, and then Central Bank of Nigeria versus Aminu Umar of 2021, both of Justice Division, I answered that argument this way. And this is what I said in those judgments. I said, I am not aware of the argument, unaware of the argument in some quarters that the decision of the apex court in CBN versus Interstellar was rather based on the fact that the Attorney General was in that case held to have given his consent by implication to the garnishee proceedings. He had been earlier instructed some payment of judgment debt in issue before the commencement of the garnishee proceedings. It is thus argued that that is the real basis or ratio decedenda of CBN versus Interstellar and not his pronouncement, distinguishing Ibrahim versus JSC and affirming emphatically, quote, that the appellant, that is Central Bank, does not stand as a public officer in this situation. Therefore, it follows that the need to seek the consent of the Attorney General does not arise, end quote. I said I am not by any means persuaded by that argument, given the very clear pronouncement of Ogumbi JSC in a lead judgment as shown above, directly distinguishing its earlier limitation statutes / public officers protection law case of Ibrahim versus JSC, where public officer was defined as including an artificial person's office as shown in the passage of our Lordship's earlier judgment earlier reproduced. I said it has to be noted too that our Lordship even went further to say that this constitution in purification tech, that's Court of Appeal, versus Attorney General of Lagos State, was on, quote, all fours, quote and end quote, with CBN. And then I went on to say that incidentally, purification tech did not involve any issue of the Attorney General giving a prior instruction for payment of judgment debt. It was rather simply about the instant issue of whether prior consent of Attorney General is a condition precedent under Section 84 of the Sheriff and Civil Process Act to attach debts of government debt core customer of the Central Bank of Nigeria. It is thus my humble opinion still that the decision of the apex court in CBN was simply to the effect that prior consent of the Attorney General is not a condition precedent under Section 84 of the Sheriff and Civil Process Act. In any case, even if the finding of the apex court in CBN versus Interstellar to the fact that the Attorney General by his actions in that case by directing payment of debt prior to the commencement of proceedings or garnishee proceedings had given his consent to the attachment, that would only be one of two rationis decidendi for the decision, and not that it is that in any way reduces to a mere obiter dictum. His earlier clear decision that Attorney General's consent is not needed to commence garnishee proceedings against the Central Bank of Nigeria to attach debts due to a judgment debtor customer. For as it was said by Karibi White again in lead judgment in Aeroflot Soviet Airlines versus United Bank for Africa, 1986, 3 Nigerian Criminal Reports per 27, his Lordship said there that it is well settled that where two reasons are given for a judgment, they may both constitute the ratio decidendi for such judgment. Jacobs versus LCC, London Jewelries versus Stentoro. A reason given by a judgment is not to be regarded as obiter merely because another reason, equally valid, was also given, end quote. I said this pronouncement of mine was cited with approval and in extenso by the Cardinal Division of the Court of Appeal per my learned brother Peter Afen in his leading judgments in the cases of Central Bank of Nigeria versus Okechukwu and Eco Bank versus Admiral Environmental Care Limited. I said these two cases also settled the point that having regard to the definition of public officer, first in Section 83A of the SPCA and 18 of the Interpretation Act, which in turn relies on interpretation of the phrase public officer as defined by the 1999 Constitution of this country, public officer clearly refers to only a natural person capable of taking up employment in the public service of the Federation of States, as stated in Section 318 of the 1999 Constitution, and does not include nor contemplate an inanimate institution like Central Bank of Nigeria. That is also in keeping with the decision of the apex court by Ogumbi in Interstellar's case. So my opinion at the end of the day is still that Section 84 of the Sheriff and Process Act, to the extent that it makes consent of the Attorney General a precondition for attachment of monies belonging to government and its agencies, is unconstitutional. But before signing on, I would even suggest, by way of law constitutional reform, that since it is also part of the subject of this constitution of this discourse, that Section 251D of the 1999 Constitution of the Federal Republic of Nigeria conferring exclusive jurisdiction on the Federal High Court, when it says that connected with any matter connected with or pertaining to banking, banks, other financial institutions, including any action between one bank and another, and any action or against Central Bank of Nigeria arising from banking, foreign exchange, coinage, legal tender, abuse of exchange, leaders of this, blah, blah, blah. I said that section should be amended to also transfer garnishee proceedings to the proviso, because by saying that any action by or against Central Bank of Nigeria arising from banking, surely, and then conferring jurisdiction on such matters on the Federal High Court exclusively, it necessarily means that garnishee proceedings must also go to Federal High Court. In other words, even if you obtain judgment in the State High Court, you have to go to the Federal High Court if the central bank is the garnishee you are pursuing. That is clear to me when it says that including any action between one bank and any action by or against the Central Bank of Nigeria arising from banking. So when you proceed against central bank, that is what you are doing. Fortunately, the proviso of that section says, like I said, ordinary matters between banks and their customers can be taken up either at the Federal High Court or at the State High Court. It does not give it exclusive jurisdiction. So that is the point I'm trying to make, that this provision for purpose of this should be amended so that garnishee proceedings can be taken in the same court and not necessarily when you get judgment in the State High Court. You now, if the central bank is involved, you now have to go to Federal High Court. It doesn't make much of sense. I said it should be amended to also transfer garnishee proceedings to the proviso. In fact, two occurs. My learned brothers, first Ekanem, my friend Joseph Ekanem, and even Agim JC as a then was, in two cases which I cited. One of them is Central Bank of Nigeria versus Kakuri, reported by Law Pavilion. And then the other one is Central Bank of Nigeria versus Igbadu. All of them are to the effect that if you must take a garnishee proceeding against central bank, you must follow 251(1)(d) religiously and go to the Federal High Court. Otherwise, if you just go blindly back to the court, the State High Court, which you normally take, then your proceeding will be the State High Court will be without jurisdiction. Fortunately, I was also forced to follow those judgments, even as I didn't quite like it, but I was bound. So that is my own contribution on the same issue. Thank you for your audience. Thank you, gentlemen, for everything. So I think I now throw the floor open for comments. We'll take how many comments? Okay. I guess my brothers, the Leonard Silk, the earlier, my brothers Kelechi Obi and Unwao are there so that they can also hear us. So comments, we'll take like, I think, how many hands are there? We will not be able to take all of them. Okay. So we take 2 from each side and 2 from this side. So you have to pray that you are one of the lucky 2. Probably I can see about 4 hands here up. You can probably discuss and then put all your questions to one person in case it doesn't get to you. And the same thing on this side. So we start from this side. We start from Leonard Silk, Mrs. Bomalabi.
I'm most grateful, my Lord. Mine is simply a comment, and it's to say that I align myself with the view that, of course, the judgment debtor has a place in the garnishee proceedings. At the same time, we have to be careful so that our colleagues, who we know what they do in the courtrooms, do not use that opportunity to reopen the entire case. It has to be limited to issues relating with the garnishee proceedings. And rather than leave that to their good sense, which in my experience is rather, there's a paucity of good sense in much of the legal profession, we ought to set out some directions and make it clear what's acceptable at this stage and what isn't. Thank you.
Thank you, Leonard Silk. I think I should have mentioned it, though I said it in my paper, but because of time I had to distinguish it. That part of the law is well settled that even the garnishee, let alone a judgment debtor, cannot reopen, cannot contest the merits of the judgment in a garnishee proceeding. That one is settled from Genesis to Revelation. So I think it does not, I guess counsel will understand. Yes, let us come this way. I'll come back to you. Now it has to be a man, 2 men and 2 women. Let me see the one with the. No. Not the one. You see, if you are coming for this kind of event, I always insist you come dressed as a lawyer. So if you are not dressed as a lawyer, which is black and white, I will not recognize you. I'm sorry to say so. Before the death of our sage, Oputa, in, I think that was in 2002, law NBA conference in Enugu. He presented a paper that is Justice Oputa himself. And he stood up. Sorry for digressing. And then somebody was wearing a hat. And then he said, you see, I had to dress like this. He was wearing striped trousers. The lawyer has a striped trousers. So I had to dress to make a statement, that you are here and you cannot be dressed like this. This is a lawyer's occasion. Some people started throwing away their caps, And 2 years back, I was in Cambridge, for an event, Jesus College. I went like we normally do here. I went without wearing my blacks. I saw colored suit. I was almost embarrassed. Nobody spoke to me. But all the British lawyers, everybody, the lawyers, judges, retired, serving, everybody was dressed black and white. Directly. Everybody. That is how it ought to be. So this is a law occasion. So we have our colors. You cannot go and join the army wearing something else and when they're on parade. So for anybody that is not dressed like a lawyer, sorry, I will not recognize you. Others maybe. Yes. So the gentleman there, please. You gentleman there. Yes.
Good afternoon, my lords and everybody here. My name is S.G. Ahmad from Kano branch. My question goes to Professor Akume. Sir, when you were making your presentation, you said that a lawyer should not just go to a judgment creditor, should not take all the banks to the court for a garnishi. He has to do his due diligence to find out whether the judgment debtor has money in a particular bank. Please, sir, how can a judgment creditor know that the judgment debtor has money in social account? He will not disclose it to him, nor can the bank do so. So I just want to ask Professor to help us the way we should find out whether such person has money in such a bank. Thank you, sir.
I have decided to use my powers as chairman to add one more to the 4, probably even 2. So we come back this way again. Yes, who is there? The lady at the back. Oh, so my issue about dressing has now reduced the numbers. I can see.
Thank you, my lord. And what a rich session we've had on garnishi. My lord, I'm trying to see how we can really improve on the jurisprudence of garnishi. And I'm happy that the second speaker that joined us virtually has mentioned that the sheriff has gone up for review, which is very good. I'm trying to know how we can do judicial activism or bar activism to really see if we can now subject garnishi to mediation, because truly it's not easy to say CBN has the single treasury policy and then you want to garnish a bank who tells us that their treasury is in the custody of CBN and that they cannot do anything about it. My lord, the banks also have issues. They think because they have to really have client confidentiality, they don't disclose. We've been having these issues over and over again when it comes to garnish procedures. Again, my lord, how, for the life of us, can we garnish a government parastatal in its absolute power For example, a ministry in federal parastatal. You want to garnish it, and they are making it very, very, very hard for us. In fact, they are telling us that you cannot garnish a federal government because we are in power. These are issues that are very germane and are not allowing the dispensation of justice to flow through when it comes to garnishing, my Lord. So I'm asking, is there a way that this Sheriff Process Act, is there a way we can also have a voice, or can be lent a voice to say, please let garnishing be subjected to a form of mediation where the judgment debtor, so that the judgment debtor doesn't come even where the nice side is, but ab initio, the judgment debtor, the creditor, or whoever is responsible can sit in a form of a mediation circle and say, all right, judgment debtor, this is it. Just disclose what do you have, where, and how, and then make things a little bit easier so that justice can be seen to be done on all sides. So, sir, please, this is my submission, and I pray that the prayers will be heard. Thank you, sir.
Thank you.
Oh, I'm sorry, I'm P.E. Kwatwa from Kano branch.
What's the name? What's the name, sorry?
I'm P. Kwatwa, my Lord, from Kano branch.
Okay, thank you. Any other hand again? Oh, so all the hands were from those who are not really dressed for the occasion. Probably we should take one of them if they are still willing. Okay. At least it's the first time. Let us, we have taken three. Let us take the fourth one. So, gentlemen, please make it fast.
My lords, I think, my lord, one of the problem we have regarding the garnishee proceedings is consistent inconsistencies of the judgments of courts. That is number one, my lord. For instance, now, the issue as to whether a judgment debtor is a party to garnishee proceedings or not. There are so many decisions of the Court of Appeal, and in 2019, the Supreme Court, in the case of Ogwede versus Cross River House of Assembly, said judgment debtor can be heard, but within the limited compass. But in 2022, that judgment of Ogwede versus Cross River House of Assembly, the lead judgment was delivered by Okoro JSC. And in 2022, another judgment of the Supreme Court in the case of FBN versus Yegwa, the said Supreme Court said a judgment debtor is not a party to the garnishee proceedings. So there are so many conflicting decisions virtually on all the points in garnishee proceedings, to the whether monies belonging to the government can be attached, whether a judgment debtor is a party to the garnishee proceedings, whether during the pendency of a motion for stay of execution, a judgment garnishee proceeding can proceed, whether a judgment of the State High Court can, if the CBN is a party, can be imposed before the Federal High Court, virtually in all the segment of the garnishee proceeding. So unless those conflicting decisions are reconciled, either by the Court of Appeal or by the Supreme Court, the garnishee proceeding will proceed to become a simple but delicate process for executing a monetary judgment. And lastly, my lord, regarding whether somebody has to conduct a thorough investigation before filing a garnishee proceedings. Because of the confidentiality between bank and its customer, it is almost impracticable, if not impossible, for someone to have a detail of a judgment data from a bank. That is why in the case of Oladipo, Oceanic Bank versus Oladipo, Mbaba JSCA, thank you, held that it is not mandatory for an applicant in garnishee proceeding to supply the account number of the judgment data because of the confidentiality between the bank and its customer. Thank you, my noble Lord.
I think we'll stop at this point. Mr. Fari, I particularly understand your interest in Ganishi proceeding, because it's almost always before us on fundamental rights matters, and against 10 million, 20 million, this, that, against government on a regular basis. And all those ones you will need to proceed only by way of Ganishi proceedings. Now, what I find a little bit difficult is the complaint of the lady there of the Kano branch that she was finding it difficult to go on with the Ganishi proceeding or whatever. I find it difficult because when you commence a Ganishi proceeding, when it's even against the bank, the understanding, particularly in banks, is that when you put money into the bank is indebted to the depositor. That is what makes the bank a debtor. That is why they call the monies a debt. In fact, the authorities even say that. The bank is paying his own money, not the money you put in there. So it's indebted. So if the bank doesn't want to pay, if you have an order absolute, if you have secured a Ganishi order absolute, and the bank doesn't want to pay, the banker here has told us, it's very easy. To me, that's the way I see it. You go to the bank, this is not government this time, get the sheriffs, go and pack their generator and other things, enter the bank and carry their computers. Lo and behold, they will pay you immediately. So I'm surprised that Madam there, the lady there is saying that she's finding problems. It shouldn't be. They don't have such coercive powers like probably central bank will go and get their decision to say you cannot enter here. They don't have such powers. And then Fari, I understand your points. Your point is well made. Having said that, I think my learned brother here and the professor to whom specific question was directed would want to say something on it. So, my Lord, can you, sir?
Thank you, my Lord. The question about how do you get the specific bank with money, I think it's because in many situations, counsel sit in their office waiting for these things to come. If you do your private investigations, very often the client knows the account number. Even where he does not know the account number, there are clever ways you can get the account number. I have done a case where CBN was the garnishee, the judgment creditor was an army officer, and he was able to get the account number of the army in CBN. How did he get it? So there are ways, if you're serious about getting it, you will get. Just to show you how absurd CBN can go, I just want to draw your attention to this particular case. The case is CBN versus Lieutenant Commander Isaac Okpanachi. Is a 2022 decision of the Supreme Court. And what was the argument? A decision of National Industrial Court by the Constitution, if there's an appeal over any civil matter to the Court of Appeal, if Court of Appeal decides, it is final. Now, there was a garnishing proceedings against CBN in respect of a decision from National Industrial Court. And when the Court of Appeal decided the matter, CBN decided to go on appeal to Supreme Court. And their argument was that the finality of Court of Appeal decisions over appeals from National Industrial Court cannot be read to include garnishing proceedings. And that garnishing proceedings are separate, not contemplated. But of course, the central bank, the Supreme Court said no. Garnishing proceedings are a continuation of the civil jurisdiction of the National Industrial Court, And so whatever the Court of Appeal does in respect of them is final. So they threw away the case on the grounds that they had no jurisdiction to take such an appeal, since the Constitution says matters from NIC must terminate at the Court of Appeal.
Prof, please, over to you. Okay. Okay, your own.
What I would advise is that the parties involved should go underground. How you obtain your documents does not vitiate the relevancy of such documents when you use them. So, if you want, you can see me privately. I've been a very active ASU member. I will tell you how we get government documents. But I can assure you, Nigerians are very hungry. If you know somebody who knows somebody who works in any bank, if you just make an inquiry and tip the person, they will open the computer, they will check, and they will advise you the person doesn't have an account with us. Nobody will ever know. And accounts are linked through BVN. If you go to one bank, they can tell you, if they find that the person has an account, they will say he has an account, and this account is linked to another one in Fidelity, and another one in this bank, and then quietly you go back and file your thing. So the opening a computer and checking, even if it is your friend that knows somebody who works in one bank, discreetly it will be done, and then quietly they will tell you, yes, the person has an account with us and with UB and the rest. So you pay money for that and get people, you do your investigation. In Nigeria, nothing is impossible. This is Nigeria. Thank you.
I just said, sorry, my Prof. I just said probably that for those who want to come to Prof, it's not free. Oh. You get your consultation fee. Prof is not free. So when he says come, get yourself ready. Thank you, gentlemen.
Thank you very much, my Lord. Thank you, Chairman of Session. Please, can we be a bit more generous? Put your hands together for this session, please. Thank you. I will, at this point, invite the President of the NBA. Few minutes. Thank you. Grateful.
Thank you very much. I was going to advise the Prof to put off his mic when he was talking about how you can get documents from the banks. But I just said that it's good we appreciate our speakers, all of them that spoke virtually. And here in the room, Professor already, my Lord, the chair of this panel, has commended the Prof for his passion in sharing his knowledge with respect to this subject. And we thank you for offering that advice. I'm sure many of us will come and see you privately to find out how these things can be done easily. And I go to my Lord, the President of the National Industrial Court. I just want everybody here to know that my Lord was not scheduled to be on this panel originally. My Lord just came to participate just like every one of us. And when we saw that there is a third seat here and it would look awkward to not have a third seat, and I know personally that my Lord has done a lot of work on these Ganishi proceedings. I personally know. Yesterday I told you that my Lord is my teacher. Even as president, if I write something or I write my briefs, it doesn't get to court in most cases until it passes through that furnace of my Lord, the President of the National Industrial Court. And you remember yesterday I said, just call him to say, sir, I haven't seen you in a while, and I just called to say hello. And if you make the mistake, in quotes, mistake of talking about, for instance, this subject of Ganishi proceedings, holding his phone like he did today, that was a typical telephone conversation you would have with his lordship. And so my Lord wasn't part of the panel. We conscripted him and begged him to go and sit there, and you can see how much my Lord shared with us this evening. My Lord, we'd like to appreciate you for always being there for us. And then to the chair of the session. Well, number one, the chair of the session was just meant to come as a speaker, as a panelist himself, to share his thoughts and go, but he combined the two responsibilities. Of course, we are not surprised. My Lord is a presiding justice of the Court of Appeal, so he can chair the panel, as it were, and also participate in the conduct of the proceedings. But then, my Lord, I would like to thank you on behalf of the bar for your boldness in confronting issues of ethics and professionalism. You did that today when you wouldn't allow someone who was not properly dressed, who is not properly dressed, to speak in this place. That is something that I found very profound, something that is evidently missing with the courts, and we've been asking for that cooperation so that we can deal with these issues of professional misconduct amongst us. And I would like to use this opportunity to publicly acknowledge your Lordship's courage. My Lord sat in that presidential election petition proceedings at the Court of Appeal, and counsel who came there and did all sorts of things that were unethical and unprofessional. My Lord, in your judgment, did not spare any effort at condemning those actions. And my Lord, before the decision came down from the Supreme Court, most of the lawyers who appeared before the Supreme Court had the guts to grant interviews where they said all sorts of things about the Supreme Court. And then that judgment came from the Supreme Court without a mention, without a reference, without any word, any statement condemning the conduct of those lawyers. My Lord, that didn't send the right signal to our colleagues. And that is why we continue to see cases of professional misconduct here and there. And it is hurting the system. And my Lord, I had the opportunity, I want to say it here, that I'm just doing this publicly in your Lordship's presence. This is something that I did before the Supreme Court at the last Supreme Court, the opening of the legal year of the Supreme Court. I said it to them so that no one would mistake me for patronizing my Lord. And I'll read from that portion of my paper before the Supreme Court. And I was talking about this issue of professional misconduct. And I said, talking about our members, I said, those members of the bar who claim justices collect bribes should quit being cowards and make bold to present the evidence to law enforcement agencies, even when the bribes are allegedly given by or through them. It is a sacrifice we must make to save the nation. I therefore call on the judge who alleged that a senior counsel attempted to bribe the tribunal in Kano to forward the particulars of the counsel to us for disciplinary action. If this cannot be done because the allegation was unfounded, the bar demands an apology, just as I have severally done for the unwarranted hurt caused your lordships by members of the bar. I must in this wise commend the Court of Appeal by Honorable Justice Ugo Moses and Honorable Justice Nisitura Bolaji Yusuf in that bold step of calling out and condemning the actions of members of the bar who decided and treated the courts derogatorily. With due respect to this honorable court, and I was addressing the Supreme Court, the failure of your lordships to invoke the court's coercive powers, despite the discourteous and irreverent manner in which some members of the bar treated the court in the wake of the presidential appeal proceedings before the court, the threats, outright abuses, and derogatory remarks after the proceedings did not help in sending the right signal to the public and worsen the perception of the public about the court and the judiciary at large. That the court did nothing, that the Supreme Court did nothing, did not punish those who clearly went on a spree to denigrate the courts and the institution of the judiciary, made the public think that what was said of the court were true. My Lord, this is what I said, and I repeat it before your Lordship, and I would like to thank your Lordship for that show of courage. What your Lordship did alongside my Lord Honorable Justice Bolaji Yusuf is to help preserve this country by causing our colleagues to live up to their own responsibilities and be ethical and professional in the conduct at our responsibility. And then what is more, I have the singular honor and privilege of announcing that my Lord Honorable Justice Ugo is also my callmate. I thank you, my Lord, sir.
Thank you very much, Mr. President. Photo session. Photo session, please. Our eminent panelists, and I pray they be joined by, our senior colleagues on the front row. We thank all of you, those who joined us virtually. Thank you very much.